Hi, it's Gene Trowbridge at the Trowbridge Law Group. We're syndication and crowdfunding lawyers, and our practice is primarily related to securities, securities offerings covering real estate. And this is the 2023 primer that I put together to give you the basics. Now, there's a lot of stuff on our YouTube channel, and we offer virtual classes and live classes if you want more in-depth knowledge about this. But for right now, I think I have 16 slides. We're going to go through that, and this will give you the basics of what's happening when you want to form a group of investors to buy a piece of property. That takes you into the securities laws and takes you away from the real estate law. So let's go and let's see what it is. First of all, who am I and why am I saying this? I'm the founding partner of Trowbridge Law Group. I was a syndicator for about 20 years, building primarily self-storage facilities. And at 45, I went to law school, became a lawyer, and have been practicing syndication law specifically and exclusively since then. And we've represented over 650 unique sponsors who have raised over $6 billion in their securities offerings. If some of you know what a CCIM is and the CCIM education program, I was a senior instructor there for 40 years. I've now retired from that position and am a senior emeritus at the Institute. And I'm the author of a book. It's called It's a Whole New Business, and we're in the 4th edition, and I'll talk to you about that later. And later there's going to be a QR code that's going to pop up on the screen that if you click on the QR code, we've made arrangements for you to get a free PDF copy of the book by return email. So that's who I am. And let's talk about how important this business is. The scope of private placement offerings is an important topic. Every 12 months, the SEC comes out with information about what's happening. They gather information from us when we file what's called a Form D, and that information is gathered and compiled. And the most recent report we have now, there'll be a new one coming out in March of 2023. But the most recent one we have right now is that there was over $2.2 trillion raised in the last 12-month period in private placements. Now, this primer has all sorts of vocabulary. A private placement means we're generally not advertising. We're not going to Wall Street. We're not listed on the stock market exchange. It's a private offering, and most of it is going to be from people that you know who will invest with you. More than 2/3 of the offerings have less than 10 investors, with the average being 14. So we're not talking about real large funds. There are just an awful lot of them. $1.9 trillion was raised in something called 506B, which we'll learn about, and $2.17 billion was raised in 506C. Now, 99% of all the exempt capital is raised under 506. Well, here's vocabulary: exempt. Every security has to be registered with the SEC unless it's exempt. And Regulation D and its rules 506B and 506C is a great place for doing your securities offerings and not having to go to Wall Street, not having to go to the SEC and spend hundreds of thousands of dollars and months and months and months getting your offer approved. Private placements are exempt from filing with the SEC. And actually, there was more money raised in private placements during this particular 12-month period of time than there was raised on Wall Street in initial public offerings. So this is where a lot of money is raised. This is where a lot of businesses get their capital so they can go out and expand and hire people. The reason Congress and the SEC is so interested in these private placements is it's really a place for capital formation and job creation. So they want to make sure that this space continues to work well. Let's talk about this space for a little bit. If you were going to buy a piece of property yourself, every good attorney would suggest that you buy it inside of an LLC or a limited partnership, but today it's almost all LLCs. The LLC covers the property with a code of limited liability. So if anything happens in the operation of the property stands for the loss, not the individuals behind it. And you can't go any farther than that. The one asset is covered by the LLC, and that's asset protection. So that's really important. And then you would be the member. You would invest your money in the LLC. The LLC would own the property. The LLC would be the borrower on the loan. You probably will have to sign the loan because you're the individual. They'll underwrite you, just like when you buy a house. They appraise the house, and then they qualify you. Well, this is exactly what would happen if it was a single member LLC buying a piece of property. They appraise the property, and then they underwrite you. So that's how all of us got started in investing. Now, where that changes is when we have a number of investors. And in this diagram, we still have investment LLC, which is formed to own a property. We have members who purchase interest in the investment LLC, and then they get cash distributions from operations and sale. But because there are so many members, we need to have a manager manage the entity. And that's what manager LLC is. Once again, investment LLC is important because we want the property and all that activity to be covered in an envelope of limited liability. The managers also want to be protected through limited liability, so they will form an LLC themselves. And one other picture on this graph is that sometimes the lender is going to require an enhancer. A typical example would be if the manager did not have enough net worth to qualify for the loan, we would go out and get an enhancer, a sponsor, a key principal, an angel investor, whatever you call it. I call it enhancers, to bring in some net worth and to agree to sign on the mortgage. And that, of course, that signature is valuable, and they would probably get compensated for that. But we have the members investing in investment LLC. And why are they doing that? Because it looks like there's going to be a profit. We're going to buy some real estate. We're going to rent it out. It's going to go up in value, and we're going to get profits through operations and disposition. And because there are so many members, it's going to be manager managed. This is the start of a discussion of a security. I'm going to say this. The members invest their money in a common enterprise, which is investment LLC. They do it because there is an expectation of profit, but that profit's going to occur through the activities and the management of the manager, the sponsor. So the government is interested in protecting all those members who are investing in investment LLC and are kind of at the whims of whoever the manager is. So back in the 1930s, they passed a couple of securities laws right after the major stock market crash. And two laws, one in 33 and one in 34. The first law was to protect the investors against fraudulent investments. And the premise of that law was we needed to set aside a program where the investors would be told everything they needed to know to make an informed decision. I think the specific language is all the material facts ahead of time so they can make an informed decision. Well, that's important. The other law, the 34 Act, was to protect the investors from individuals who sold fraudulent investments through fraud and deceit. The 34 law was the one that designed the setup of the SEC, the licensing authority that the SEC has to license salespeople of securities. We don't necessarily need to worry about the 34 law and the licensing when we're doing our own syndication. You all have heard about for sale by owner in the real estate industry, where I can sell my own house, but I can't sell yours unless I have a real estate license. That's similar in the securities world, where I can sell my own securities, but I can't sell yours unless I have a securities license. So what we're going to be talking about in the rest of this primer is when you put together your own securities offering and you go out and sell it. In that case, you won't need a securities license. So a long time ago, there was a court case, and the court case was important because in the definition of a security, the term investment contract popped up, and no one knew what an investment contract was. And so along came a case. It was called Howie. And if you read about securities laws, this is going to be the case you will read about. And it's kind of interesting. It's a case on real estate. And it turned out to be that the courts felt that whatever happened in this case was a perfect example of what they meant by investment contract. And so what happened was they said an investment contract will be something, and you'll know it because it's an investment of money in a common enterprise with an expectation of profit solely from the efforts of a promoter. Just quickly, what Howie was is people were buying lots in a citrus farm. The citrus farmer said, we'll take care of everything. We'll raise the citrus. We'll pay you. We'll sell it. We'll pay you your share. And with that, you can buy the land on the land contract. Howie went bankrupt. People sued, and they sued to say that Howie actually hadn't been selling real estate. Howie had been selling a security. And what was it? They were all investing their money into this agricultural company. They expected to get a profit, and it was all going to be driven by the officers of the company. And it went bankrupt and on and went to court. And they said, well, we're going to call this a security. So that takes us back to this picture where the members invest their money in the common enterprise of investment LLC, which is designed to own a property. There's a profit expectation, a profit motive. That's the only reason you do this. This is not donative. This is not, oh, I need braces. I'm going to start a GoFundMe page, send me money, and I'll get my teeth fixed. No. This is, here's a business opportunity. We think there's a profit. You can invest and you can share in the profit. And, oh, by the way, you don't have to do any of the work. We're going to do the work. An investment of money, common enterprise, expectation of profit through the results of the promoter. And the promoter is the manager LLC. There was no promoter. There was no manager in the member managed LLC that we started out with. The members made all the decisions. They managed their own money, And that's going to be difficult if there get to be too many people. You're going to have to put someone in charge. Another way of talking about what's a security I like to talk about is when a group of people give their money to someone and that someone manages it for them. The investors are passive. The manager is active and makes all the decisions. Well, it's good that the government is interested in protecting the members in that situation where someone else is managing their money, and that's why we have the securities laws. Now, this is a pretty nice little flow chart, and if you read my book, you'll see a lot more about this. But the question is, and this is a question we get when clients call us in the office, hey, Gene, I want to put 10 people together to buy a building. I don't want it to be a security. Okay. Well, the only way it's not a security is if it's member managed. If those 10 people make all the decisions themselves and they all have equal votes, regardless of how much money they put in, no one can control another person's vote. So that's very, very difficult to do with any large number of investors, 3, 4 maybe, but you get more than that. It's just very, very difficult. So a member-managed LLC, there's no manager, there's no enhancers, is not a security. But a manager-managed LLC is a security. By definition, a general partnership, which you've heard of with a GP and LPs, that's by definition a security because the general partner makes all the decisions and the LPs make none. In an LLC, the manager will make most of the decisions, but sometimes decisions can be left to the members and they can vote on them, but it's still a security. So if you're going to have a manager-managed LLC, here you go right into the securities world. Every security has to be registered with the SEC unless it's exempt. So in my picture, we have these red boxes, offerings exempt from SEC registration, and the major area is Regulation D. It's not public offerings, it's not small public offerings, it's not Regulation A, it's offerings that are exempt from SEC registration under Regulation D. Now, Regulation D today has two parts of it. The first part is called Regulation D 506B. And this is a holdover from when Regulation D was introduced in 1981. We created something called Rule 506. And in Rule 506, the rules were you could raise as much money as you want. There's no limit. You can have as many accredited investors as you want. Accredited investors are rich or smart. That was the old rules, but you'll see rich or smart, and they can make the decisions themselves. You have to give them all the information, all the material facts. Then they can study that. If they have any questions, they can come to you, get their questions answered, and they can invest. The government doesn't necessarily think the accredited investors needs the protection of the government. Because you know these investors, and we're going to find out pretty soon that in 506B there's no advertising, so you're going to know who your investors are. We can just have the investors check a box, and there are 9 or 10 levels of how you can be accredited, and the investor will read through there and check the box that applies to them. Because you know them, the chances are you could tell if someone was lying to you. In an effort to promote capital formation, they did create a prong of this rule that says you can have 35 sophisticated investors. And that's too much to go into here, but a sophisticated investor is not accredited, but knows enough about what's happening, being able to read the documents, being able to have an advisor, or figure it out for themselves to determine if the investment has an appropriate amount of risk for them. So you can have 35 sophisticated investors. A PPM will be required if there's one sophisticated investor. It says recommended or required. Well, if every investor is accredited, you don't need a PPM by definition, but you still have to give everyone all the material facts. So how are you going to do it? And how are you going to prove that you've done it? Again, some of their claims that, oh, you didn't tell me that. Put it in writing and give it to them. That's what securities attorneys do. We draft the private placement memorandums, the operating agreement, and all the documents necessary to comply with the securities laws. 506, when it came out in the early 80s, no advertising or solicitation. You had to know everyone who was going to invest with you. And that stayed the same for a long time. In 2012, Congress passed the Jobs Act. And the Jobs Act, which was made official in 2013, added 506C, a new exemption rule under Regulation D. Remember, Regulation D is great because you don't have to register with the SEC. All you have to do is send an information form, which is called a Form D, to them, and then they use that for gathering facts. But there's no approval of your offering. There's nothing. But if you went to register your offering, every word is researched and dealt with. 506C came along, and the real issue in 506C is it allowed advertising. You could still raise as much as you want from as many accredited investors as you want, but because you don't know them, you probably have to have a third party verify that they're accredited. The language is that the sponsor has taken steps to be reasonably assured that the investors are accredited, and there are all sorts of third-party companies out there that will do that for you. No sophisticated investors, because we're advertising. We're taking people you don't know. So we're not sure that they can understand the documents and understand the amount of risk they're involved with. A PPM is recommended. Once again, if everyone's accredited, which they will be, you wouldn't have to have a PPM. But how do you know if there's 10, 25, 100 investors that you've told everyone the same thing at the same time? So you still have the obligation of giving the investors all the material facts so they can make an informed decision. And in our firm, every offering gets a private placement memorandum, a PPM. And advertising and solicitation is allowed. Now, we don't have to go into that. It's just anything you can think of. It's social media, it's television, it's radio, anything you can think of where you're attracting people that you don't know and offering them a chance to invest with you. Now, one of the things we saw in the second or third slide is of the $2 trillion that's raised in private placements, 1.9 trillion is raised in 506B. Now, that's the lion's share, obviously. And why is that? Well, a lot of the securities offerings are done through broker-dealers, licensed security brokers, and they have relations with people. They have Rolodexes or databases, and so they don't advertise for new clients. They have plenty of clients. In fact, our firm's most prolific syndicator, who's done over 160 offerings with us since 2014, does 506B, but limits it only to accredited investors. Well, that's fine. And the beauty there is there doesn't have to be a third-party verification. The accredited investors can just check the box. No one needs to look at their income tax return or anything. So that's good. And this particular client really doesn't need any new investors. Everything comes word of mouth. Word of mouth referrals are not advertising. So Generally, if you're going to start out doing a deal, you're going to start with a 506B, and you're going to raise money from people who know you and would like to take a chance investing with you, because you can present them some opportunities that they can't do on themselves. Not everyone can buy a piece of real estate, manage it, have enough money, know about it. So investing in a syndication is a good idea for them. And you'll probably do your first deal in 506B, because the chances of someone you don't know sending you a $50,000 check when you've never done a deal before is pretty slim. So the 506C people, are probably the people that have a track record. Now there's a bunch of words. Sophisticated investor, remember? 35 investors who are sophisticated in a 506B. Read about it in the book. Investors who on their own, through their education and their training, or through an advisor, can figure out what's going on, can read the documents, and determine if the risk is right for them. Pre-existing and substantive have to deal with how do you defend yourself on an advertising charge when someone says, oh, I didn't know Gene, he advertised, and this is a 506B and it went terribly wrong. Well, your defense is you're only selling to people that you had a relationship with prior to your offering coming out, and that relation was substantive. You knew that they were accredited, or you knew that they were sophisticated, and they knew enough about your business to be interested in investing. No advertising, no radio, no TV, no social media. So those are words that you probably want to study if you're going to do more of this. What syndicators say, they say the care and maintenance of partners is overwhelming. I left the syndication business after a year where I sent out about 1,800 K1s, and I was representing over 850 investors. And back then, there were no companies to help you in the back office. You did everything yourself. Today, there are companies that'll help you, and it's a little easier. But at the care and maintenance, I mean, this is really a people business, much more than a real estate business. You'll buy a piece of real estate, it might not even be in your state. You'll hire a professional manager close to the piece of real estate, and your job really is working with the investors. Very much of a people business. Another thing that syndicators say is the risk is greater than they expect. Now, I've talked about a private placement memorandum where we're supposed to put all the material facts in so the investor can learn about them ahead of time to make an informed decision. But as I stand here right now narrating this, we have private placement memorandums that we wrote 4 or 5 years ago that didn't talk about COVID. We have private placement memorandums that we wrote 3 years ago that didn't talk about the rapid increase in interest rates, which is causing everyone trouble. So that, you're not a crystal ball as a sponsor. You don't need to know everything that's going on, but anything that's reasonable that someone would think of is something that you should disclose in the private placement memorandum. Big mistakes, not having enough time to raise money. You want to do one of these deals, I'm suggesting it would take 120 days, 90 to 120 days from the time you identify a property, get the financing, get it purchased, get the legal work done, and get your money raised. There was a time where I could say 60 to 90, but today, here at the beginning of 2003, financing is so complicated that it's going to take you a little longer. Taking investors' money before the investment LLC bank account is open. No commingling. The investor's money can only go one place, in investment LLC. Paying finder's fees to anyone who does not have a securities license. Remember, there's a law out there that says you have to have a license to sell a security that isn't yours. So if someone comes to you and say, hey, I know some people and we can put $1 million in your deal, will you give me $25,000 if I bring them in? You have to say no. You can't do that. That's definitely against the law for you and them. The very big mistakes is drafting your own documents. You really need to hire a securities attorney to draft the documents for you and hold your hand through certainly the first deal. Not reading and following your documents. It's one thing to say, boy, I've got the best attorney in the world. He's going to give me the best documents and she's going to make sure it's spelled right and everything. But did you read it? Do you understand what happens if an investor comes to you and says, I need to get my money back? Or there's been a death in the family. Do you understand all those rules? You will if you read your documents. Making cash distributions from reserves. When you model your syndication and your cash flow pattern, you just have to make sure that the property will produce the cash flow that you think you're going to distribute. Not raising more money ahead of time and having a slush fund and then sending people their own money back. That's actually fraudulent. So that's not going to work. And cashing out investors with money from new investors. How about Bernie Madoff? That's what he did. And how about some of the things we're learning about in the cryptocurrency world? How about Ponzi scheme? That's exactly what we're talking about. Don't do that. So here is how you can get a free copy of my book. This is the 4th edition, and this one was updated for the changes in the securities law that happened last year. And if you click on that QR code, you will be able to get into my website, and with your information you give us, we will send you a free PDF of the book. There's also an opportunity to get a free hard copy if you want to pay postage. And there is an Audible version of the book on Amazon in your Kindle and your Audible store, which I narrated at the beginning of 2022 and getting a lot of sales on that. So once again, I'm Gene Trowbridge, and the firm is Trowbridge Law Group. There's our website. We have longer, more intense virtual training. We offer courses for rookies that are 3 hours of this. We have live courses, probably 3 or 4 a year, that are a day and a half where we really get into it. And we really dedicate ourselves to helping the new people get started in the business, because I, for one, know it was a great business. It just got too big for me. And at the time, I decided I'd go to law school to do one thing, to stay in the business and help other people get in the business. And that's worked pretty well for me. So don't forget to subscribe to our YouTube channel and contact us. You can sign up for a free consultation if you go to our website with Jonathan, my law partner, or myself. And hope to see you the next time, either in one of our workshops or on the next YouTube. Thank you.